make the chart?
I constructed the chart from our sales records and financial records.
Is the information contained within the chart maintained in the regular course of business at Rocker World?
It is. We update the sales data at the end of each day, and every month I audit this data.
Your Honor, at this point, permission for Mr. Longstreet to show his chart to the jury?
Defense.
Without objection, we believe the foundation's been laid.
So you're moving it into evidence as the next state exhibit?
Yes, Your Honor.
Okay.
Permission for Mr. Longstreet to step down and use his chart?
Yes, you can step down, sir.
Yes, Your Honor.
This will come in as the next state exhibit.
Now, Mr. Longstreet, what are we looking at here?
This is a chart of the daily ticket booth revenues for the 5 months in the 2012 Park season.
What is it showing us?
It shows us that throughout the entire season, we took in over $15,000 each day at the ticket booth. And in August in particular, we took in over $20,000 each day.
Thank you, Mr. Longstreet. You can take down your chart and retake your seat.
Sir.
Thank you. Now, Mr. Longstreet, I want to ask you a couple of questions about one particular ride at your park, the Tunnel of Terror.
Sure.
Do you remember who was supposed to be working the Tunnel of Terror on August 30th, 2012?
I do. That would be the normal ride operator for the Tunnel of Terror, Mr. Billy Isaacs.
Now, on this point, Mr. Longstreet, I want to be very clear. On August 30th, did you ever tell Whit Bowman to tell Billy Isaacs to leave the Tunnel of Terror?
No, absolutely not.
That day, did you ever give the defendant permission to operate that ride?
No, I certainly didn't. Whitney Bowman wasn't even allowed to operate the Tunnel of Terror.
Why not?
I had caught her operating the Tunnel of Terror in blackout mode earlier that summer.
What exactly happened?
It was after hours, and some of the employees were riding the Tunnel of Terror. Now, I walked into the tent, and I saw the ride was in blackout mode, and Whitney was behind the controls.
What is blackout mode?
It's a maintenance feature. The lights inside the tent turn off, and the cars keep on moving along the tracks. Now, it's a strictly maintenance-only feature, and normal park employees are forbidden from even touching the maintenance lever.
Why do you have such strict rules surrounding blackout mode?
It's a safety risk. When you're inside of the tent and blackout mode is engaged, you can't see what's going on, and there are still moving vehicles. For that reason, only trained maintenance personnel are allowed to activate it.
Thank you, Mr. Longstreet. I have no further questions at this time, Your Honor.
Thank you, Ms. Kitchener. Defense?
Cross-examination. Good evening, Mr. Longstreet.
Good evening.
My name is Ian Gabriel Lampert, and I have some questions to ask you on behalf of Miss Whitney Bowman.
Certainly.
On direct examination, you said something, and I wrote it down to make sure I got right. You said you were at Rocker World, and you were there when everything happened. Is that true?
That's correct.
But, sir, you would agree with me that you weren't actually in the ticket booth when Cameron Poole held up Miss Floyd at knife point, were you?
No, I wasn't. At that point, I was still in the main office.
So that means you didn't see Cameron Poole hold anybody up at knife point, right?
That's right.
That means you didn't see the knife that was allegedly used, right?
That's right.
You didn't see Cameron Poole take even a single cent of money yourself, did you?
No, as I said, I was in the main office at that time, not at the ticket booth.
So, sir, is that a yes, that you did not see Cameron Poole take even a single cent of money himself?
That's correct.
Later on, you said you ran out and you saw Haley Floyd on the ground?
I did. That was after Miss Floyd had started screaming.
At that time, you didn't see Cameron Poole anywhere, did you?
No, Miss Floyd told me that he had just robbed the ticket booth and had ran.
Sir, if I could direct you back to my question, you didn't see Cameron Poole then, is that true?
That's right.
You haven't seen Cameron Poole since, have you?
No, I haven't.
You're not sure exactly how much money, if any, Cameron Poole took, are you?
That's right. Again, I don't know the exact figures.
You have averages, don't you, that you showed us on this chart?
That's right. I have daily averages for each month as well as the midday receipts for that day.
But not exact figures, as you said, right?
No, I don't have the final receipts.
Now, sir, at no point during your conversation with Miss Floyd did she claim that it was Whitney Bowman who threatened her, right?
That's right. Again, she said that Cameron Poole had just robbed the ticket booth at Knife Point.
Whitney Bowman's name didn't come up in that conversation, did it?
No, it didn't.
Sir, let's move on and talk about a man named Detective Francis Kimball. Does that name ring a bell?
Of course.
That man is a friend of yours, right?
That's right.
Detective Francis Kimball is a former employee of yours, isn't he?
That's right. Before he joined the police academy, I employed him as a security guard for a summer.
You knew him for many years, is that true?
That's right.
Detective Francis Kimball was the man who was on the scene right after that ticket booth was allegedly robbed. Is that true?
Pardon me, you're talking about directly after the robbery?
That's correct. He was on the scene, wasn't he?
That's right. He was in the main office with me before the screaming, and then we ran out together to see what was going on.
So your friend was already there at the main office before you heard even a single scream?
That's correct. He was at the main office to discuss the day's sales and to see if we needed further investigation of some discrepancies in our records.
Your friend, Detective Francis Kimball, you're aware that he had a personal relationship with the victim in this case, Officer Winston Thomas. Is that true?
Certainly. At the time that he was working at the park, Officer Thomas was also, and still, head of security.
You're aware that that relationship between Detective Francis Kimball and Officer Winston Thomas, that relationship goes back many years. Is that true?
That's right.
Sir, isn't it a fact that Detective Francis Kimball, along with you, saw the Officer Winston Thomas's body in the Tunnel of Terror ride?
That's correct. He had arrived in the Tunnel of Terror first, after pursuing a suspect, and I arrived later, after making sure that Miss Floyd was okay.
So, sir, is that a yes, that the two of you saw Officer Thomas's body in the Tunnel of Terror?
That's right.
At that time, Detective Francis Kimball seemed to be crying to you. Is that true?
He seemed shaken. I wasn't sure if he was crying.
So he might have been crying? Is that what you'd say?
Certainly.
Sir, after that, you're aware the detective went on to conduct a series of interviews, right?
He did, yes.
The detective interviewed you, is that true?
He did. He asked me for some information about employees who he did not already have information on.
The detective asked you for Miss Whitney Bowman's address, right?
That's right, he did.
Miss Whitney Bowman's phone number, right?
He did ask me for that, yes.
He didn't ask you at that time, sir, for any information about Cameron Poole, did he?
No, as I said, he wanted information that he didn't already have about my employees.
Sir, if I could direct you back to my question, he didn't ask you a single question about Cameron Poole. Is that true?
That's right.
The fact of the matter is, sir, that as you sit there testifying, you're actually angry at Miss Bowman, aren't you?
Well, certainly. The investigation showed, or I was talking to Detective Kimball about it, that Whitney had a hand in the robbery.
So you talked to the detective who told you that, is that right?
We conversed about the investigation, that's right.
The detective is the one who told you that Whitney Bowman had a hand in this robbery.
As I said, that's right.
You never saw Whitney Bowman steal a single cent of money, did you?
No, I didn't.
Thank you, sir. I have nothing further at this time.
Thank you, Mr. Lampert. Any follow-up by the state?
No redirect, Your Honor.
Thank you.
Simply ask that my witness be excused.
You may step down.
Yes, Your Honor.
At this point, Your Honor, the state rests our case in chief and requests a brief 5-minute recess.
Okay, why don't we make it 10 minutes so that we can do some note-taking? So
Yes, Your Honor.
Court will be in recess for 10 minutes.
So we're at halftime.
We are at halftime.
Twitter wants to know, what did you think of the witnesses' tie?
I enjoyed that shirt tie combination. Much better than Mr. DeCamp's. But that's besides the point. I tell you who has a great tie on, a great suit. I know because I carried it across the street is nationally syndicated talk show host Judge Alex Ferrer.
He knows how to look great.
He looks great. I carried his suit jacket across the street. It was the most expensive thing I've ever held in my hands, I think. But he's doing a great job. He's not permitting a lot of discussion, argument on the objections.
Absolutely.
He is. He's keeping things moving along. I think he's doing an excellent job. I think the students probably wish he was letting them argue a little bit more, but, you know, it is what it is. The third witness that Princeton put up there was did what it needed to do. It wasn't a sexy witness. It wasn't a character witness. It wasn't a witness that's going to laugh, to make you laugh. It's not a witness that's going to cry on the stand. He's up there to get the facts out. Frankly, that's what he did. Nothing all that enthralling. You know, we finally saw Ian Lampert, national mock trial phenomenon. Ian Lampert, 105 pounds of just mock trial machismo.
Super consistent, clear, concise, on the money. Absolutely.
Absolutely. Not the best witness that you want to see him cross-examine. You know, ideally, in a perfect world, we'd see him cross-examining the defendant or something of that nature. But I'm sure his closing argument is going to be fantastic. Yeah. But on the whole, a very solid case in chief put on by the prosecution. I don't know what the judges think of it, but I think it was pretty strong.
You said that the case tends to play pretty evenly when you look at the history of how the rounds have performed. Do you feel like one side is really easier than the other? Would you prefer being the defense perhaps, or do you like the state's evidence here?
I'd always take the defense side.
Yeah.
If this is my team and I'm in this situation, I'm telling them to take the defense side every time. 2 reasons. Number one, I don't have a burden. If I don't have a burden of proof, you know, it's a lot easier to make arguments. All I'm doing is poking holes in the state's case in chief. Secondly, you know, someone told me yesterday this is a bit of figure skating. We are scoring these students on their performances. You know, the first side that goes, I mean, that's the baseline. The judges don't know whether the other team's going to be good or not, and I think traditionally you tend to get maybe some just very average scores. Now, if you don't do as well as the team that just went before you, yeah,
there's room to decline.
Absolutely, you're probably going to get scored lower. But I just like the opportunity going second. I would prefer to be defense. I'll be honest, we were not at the banquet. We were over here meeting with the judges, doing some judge instructions, getting ready. I don't even know who won the coin toss. I don't know who picked. Perhaps someone can come in and fill us in on that information.
We'll get it, I'm sure. So a couple of folks on Twitter are commenting about potentially some hearsay objections that were missed along the lines, particularly in the last direct examination. Did you catch anything along the way? Do you think the students are being a little timid, a little nervousness setting in for the final round in front of Judge Alex?
I think the students are picking their battles. Yeah. You know, one thing I always tell my students is to read your judges. And I think their read on Judge Ferrer right now is that he is not a huge fan of objections, and he's going to either overrule them or sustain them right away. He gave a little bit of leeway with the hearsay objections there. Sure, there's always objections missed, though. But I think that the students are deliberately kind of holding back a little bit, and it's not a bad strategy. They're reading their judges well.
Thank you for correcting me, by the way. It is so hard to call him Judge Ferrer.
It
is known as Judge Alex. I hope he doesn't mind us taking liberty with the first
I don't
name.
think
he does, right? No. So let's talk a little about the scoring process. We talked a little bit about it at the beginning, and we sort of talked around it a little bit during the time. It's important for folks who may not know to understand, it really doesn't matter who actually wins the case, if it's the prosecution or the defense, as much, right?
It does not. And as a matter of fact, right now they're showing on Twitter feed, if you want to send us questions, comments on...
We'll try to get them, actually.
Yeah, the internet went down. We are not looking at your Twitter feed right now because I think the Twitter world has crashed the internet here in the Orange County Courthouse. The scoring is this. There are 14 scores on each side. You get 10 points for each performance. Every attorney gets a score out of 10 for an opening statement, closing argument, direct examination, cross-examination. Okay. Every witness gets a score out of 10 for the direct examination and their cross-examination. At the end of the day, those are tallied up, and you get a score out of 140. And the team who scores best on that ballot, it's possible to tie. I'm not really, I don't know what would happen. I'm sure there are procedures in the tab manual if we were to tie some of these judges, but there's a reason that there's an uneven number of judges so that,
Sure.
it can shake out. But to your original question, no, not only do we not care who actually wins the trial, we don't really even ask.
Right.
We're not going to ask these judges to say, would you find this person guilty or not? The reality of the situation is when you have 3 hours to put on a complex felony murder criminal trial, I can't imagine many judges out there that would actually find in favor of the state and convict someone.
And that's in only 3 hours, to be clear.
Correct.
And
Correct.
Now, question. So there are so many real permutations of this particular case. I think we have, I'm looking at my notes correctly, there are 3 potential prosecution exclusive witnesses. There are 2 potential defense exclusive witnesses. There are 6 that can be used by either side. So every trial is naturally going to play different. Was there anything that you uniquely heard in the state's case tonight that you think has to be uniquely contended with by the defense when we see that put on in momentarily?
No, I'm going to flip the question.
Okay.
There's something that I uniquely did not hear.
Interesting.
And that is that the state of Midlands did not call Officer Francis Kimball. That's a very rare move. Most teams call Officer Kimball. Officer Kimball is the one that did the investigation. Officer Kimball is the one that arrested the Whit Bowman. Officer Kimball has a lot of good facts. A very strong witness for the state of Midlands. Princeton has made the decision strategically that they're not going to call Officer Kimball. Instead, they called the 2 character witnesses in Longstreet. I don't think they did that in error. I just think it's a little unusual. It's not. I've seen a lot of these rounds this year. I actually judged a round yesterday afternoon. And it's a little unusual that they didn't call Officer Kimball. I was expecting to see that. That was the biggest surprise.
I'm merging a couple questions here, but to that point, we talk about the scoring being so important at the actual performance level and the outcome being less so. Are there times when coaches would advise their teams to sort of give up the actual legal strategy battle in favor of playing a witness part that they feel more confident in or a little bit easier to get the points across with? How often does that come into play?
Absolutely. It comes into play all the time. You know, I've had that conversation with my students so many times. Don't worry about the little substantive things that might cause you to win a case in real life, in a court of trial, in a court of law, in an actual trial. Remember that the judges are scoring you. You know, they're scoring you on a scale of 1 to 10. And a lot of times, my mantra over the years has always been, the judges hear about 1 out of every 3 words you say. Okay? And so it's half the battle is looking the part, sounding the part, having good delivery, having good hand gestures. If you're a character, having a good costume, having a good accent, just all the accoutrements, if you will. But substances, 50-50. It's half the battle, but you really do have to focus on, at the end of the day, the judges are scoring you on a scale of 1 to 10 based upon how they like you.
Interesting. Another question for you. A lot of innovations happening tonight for, obviously, this is our first broadcast. We've got an early ratings information, by the way. We are a hit. We have 4 times as many viewers watching on clickorleno.com than happened on any other Sunday night, is what we've been told. Right. So that's pretty good. We got a big feed on Twitter, right? We also have a court reporter in the court for the first time. I don't know the answer to this. Are the students allowed to avail themselves of the court reporter to read back testimony during the finals round, despite the fact it's not available earlier on?
Because we've never done this, I don't know, but God, I would love that.
Wouldn't that be great?
If Ian Lampert stood up and said, I'd like to ask the court reporter to read that back for me. You saw the one young lady get up there with her legal pad and say, I want to make sure I get this exactly right. That's an old school move. They've been doing that in mock trial for 25 years, and that had UCLA written all over it. But wouldn't it have been great if she had stood up and said, Miss Court Reporter, read this back for me. I want you to read it back. That would have been amazing. These students, and we're seeing the court reporters right there, the crew here is fantastic.
They do
say
a great
something,
job. Boom, right on it.
Right on
Incredible.
it. It's fantastic. Later, I'm going to have them just follow Will Warahay around the entire courtroom, perhaps to the bathroom.
You're giving the secret out that we are the only two non-professionals that happen to be doing this today.
Absolutely, absolutely. There's Jonathan Woodward, tab director, in the frame there. But yeah, because this is so new with the court reporters and the fact that the students have never used them before, there's Jonathan Woodward. Had a delicious dinner at the Ravenous Pig last night.
He can't hear you.
I know he can't. Delicious dinner with Jonathan Woodward, former President David Nelmark, President-elect Justin Bernstein, Will Warehey, and I all had a delicious dinner at the Ravenous Pig here
Sounds
in Orlando.
Fantastic.
Shout out to the Ravenous Pig. No, I mean, it is so new. Everything we're doing here is so new. We've got a crowd of people here watching. I think this is quite an event to see. Every time there's a break, we've got some people coming out here seeing what we're up to, and we love it. I'm having fun.
It is a blast. So we might have some rule iterations to look forward to in the coming year to figure out how the court reporter may be integrated into finals preparations.
Absolutely.
That would be fun to see. So it's speaking along the line of preparation while folks are flying back in, it is clear. I mean, the amount of effort and energy and just sheer work that goes into preparing to compete in this competition is unbelievable. Can you give us like the short story of when the case gets released, how long it takes the teams to prepare, sort of what the process is like just to get here?
Well, the case is released usually sometime in mid-August, and the first invitationals, the practice tournaments, take place. I mean, they're earlier and earlier every year, but I mean, at this point, like the first or second week of October, so about 5 to 6 weeks later, the students are already competing using the case. The entire fall season is utilized with invitationals. There are more invitationals in January, and then the real season. The tournaments that count begin in February with our 4 weekends of regional tournaments, followed by 3 weekends of Orcs, opening round championship sites, all leading up to this tournament. So these students have been at this for 9 months, and those of us on the American Mock Trial Association Board of Directors, we're at this all year round. Once we're done with this, the students heard earlier today that there's a new case coming out next year, 2 cases coming out next year.
Really?
If you're listening at home.
That could be some breaking news.
That is breaking news, except it got broke on Twitter already.
Fair enough.
They announced, the Civil Case Committee did announce, per my reading, that not only will there be one case throughout most of the year, but there will be a separate case released after Orcs but before the National Championship Tournament. Wow. Stunning. A first for the American Mock Trial Association.
Interesting challenges ahead for 2015.
Very much so.
By the way, where do we leave Orlando? This is the last night here, and then we're off to some other city next year, as I understand it, correct?
We are.
Do you have any pull in the decision-making process here?
I have zero pull in the decision-making process.
I find that very hard to believe.
But it's a fantastic question you ask. Where can we go from Orlando? Last year we're in Washington, D.C. This year we're in Orlando. And there it is, folks. You heard it here first. Actually, you heard it last summer from the board meeting. But myself and my staff of 5 coaches at the University of Cincinnati will be hosting the 2015 National Championship Tournament, mostly because I have mental health issues. I have no idea what on God's green earth prompted me to agree to do that. But I did, and I can't wait. We have some big things in store next week.
It's going to be a lot of fun.
Looks like Judge Ferrer is taking the bench, striding up there.
About ready to begin for the defense's case.
Let's send it back over.
Thank you. Please be seated. State has rested its case. Anything before we proceed with the defense?
No, Your Honor. Ready to call our first witness.
Defense will be presenting a case.
Yes, Your Honor.
Okay. You may proceed.
The defense calls Jack Hunter to the stand.
Sir. Mr. Hunter. Mr. Lamper, you may proceed.
Yes, Your Honor. Good evening.
Evening, sir.
Could you please introduce yourself to the members of the jury?
Sure. Good evening. My name's Jack Hunter.
Mr. Hunter, what do you do for a living?
Well, right now I'm a reporter for NASCAR. I'm a journalist by trade, and I've been doing this for many years now, and actually work down at the Midlands Voice.
How'd you get involved in this field of work?
Well, I grew up on dirt tracks. I remember watching the legends of NASCAR, like Richard Petty and Dale Earnhardt on television. One day I decided I would report on them and become a NASCAR reporter. And now, I'm living the dream.
Sir, before you started working for NASCAR, what did you do?
Well, I worked at Rock the World for a series of summers.
Let's go ahead and talk about your time working at a Rock the World amusement park. When did you work there?
Well, I worked there in 2009, 2010, 2011, and the beginning of 2012, doing a bunch of odd jobs around the place.
You say odd jobs. What do you mean?
Well, for 1 year I was a janitor, and for a couple years I was a floating ride operator at the park.
Could you tell the jury what it means to be a floating ride operator?
Well, sure. When anybody called in sick or somebody had to take a break at their post, I would fill in for them.
During your time as a floating ride operator, did you ever operate the Mind Eraser?
I did indeed, yes. I did a couple times.
What about the Tunnel of Terror? Do you know that ride?
I do indeed, yes.
Did you operate that ride?
Yes, I did, twice.
Do you think you'd recognize a picture of the controls of the Tunnel of Terror if I were to show you that in court today?
I believe I would, yes.
Your Honor, permission to approach and retrieve States 1, the picture of the Tunnel of Terror?
Approach me?
No, Your Honor. Just the jury box right there.
Go right ahead.
May I approach the witness with the same?
Yes.
Thank you.
Welcome. Mr. Hunter, do you recognize that picture?
Yeah, it's the Tunnel of Terror control panel.
Your Honor, may I show the enlargement of the Tunnel of Terror control panel? The state's already shown the jury.
You can show it.
May the witness step down and make use of it?
You may step down and approach counsel, Mr. Hunter.
Thank you, Your Honor.
You could join me right here, sir.
Okay.
Mr. Hunter, are you familiar with what number 3, that blue-looking lever, depicts?
Well, sure. This is the maintenance lever for the ride.
Sir, in order to operate that lever, do you have to pull down?
Oh, no. You barely touch that thing and the lights would go out. I had to be cautious when I bellied up to the control panel a couple times.
Sir, if you could retake your seat.
Oh, no problem.
Mr. Hunter, let's go ahead and talk about some of the other people who worked at Rock the World.
Okay.
Are you familiar with Miss Whitney Bowman?
Oh, yeah, I am.
How do you know Whit?
Well, she joined the Rock the World family back in 2011.
Do you know which rides she usually worked at Rock the World?
Yeah, she usually worked the Mind Eraser.
Sir, are the controls for the Tunnel of Terror and the controls for the Mind Eraser the same?
Oh, no, they're like light and day.
What do you mean by that?
Well, you see, the Tunnel of Terror only has 3 things on it. Now, the Mind Eraser has a bunch of buttons and switches on it that you have to keep track of.
Do you know what's in the bottom right-hand corner of the Mind Eraser's control panel?
Well, sure, there's the start button and the stop button.
Sir, I want to go ahead and talk about August 30th of 2012.
Okay.
Were you at Rock the World on that day?
No, I was pulling into Atlanta Motor Speedway at the time for the 500.
Why weren't you at Rock the World?
Well, unfortunately, back in April, I was let go from the park because of a little bet I made.
A bet? Sir, what do you mean by a bet?
Well, some of the folks at the park bet whether or not I could sneak into the main office, and I took it up on them. They forgot that Longstreet kept a small window open to his office.
Sir, did you sneak in through the window?
It was a tight fit, that's for sure, but I wiggled my way through there.
Well, once you got into the main office through the window, what happened?
Well, I got in there and dusted myself off, and I took a look around, and there was Miss Floyd, the park's accountant. She was none too happy. She started yelling, "What are you doing? Get out! You're fired! Get out!"
After being fired from Rock the World in April of 2012, did you speak with anyone involved of the incident of August 30th, 2012?
Yes, after I saw what happened on the TV, I gave the lead investigator, Detective Kimball, a call.
What happened when you called the lead investigator in this case?
Well, I called him and said I had information about a series of meetings between Cameron Poole, J.C. Longstreet, and Haley Floyd.
What do you mean about information concerning meetings?
Well, you see, I remember that back in April, I saw something a little suspicious.
What do you mean by suspicious?
Well, you see, Cameron Poole, J.C. Longstreet, and Haley Floyd were meeting a whole bunch of times. It started just once a week at the beginning of the month, but as the month progressed, they were meeting 3-4 times a week. And all of this, mind you, was behind closed doors. I thought it was just kind of suspicious at the time.
So when you called the lead investigator in this case, what happened?
Well, I told him that I had information about meetings between management and Cameron Poole.
Sir, what happened next?
Well, the line went dead.
After the line went dead, what did you do?
I thought that Verizon had dropped my call again, so I called him back up.
What happened when you called the detective in this case for the second time?
Well, I told him, hey, I got information about meetings between management and Cameron Poole.
What, if anything, was the lead investigator's response?
Well, he said, never mind that. What do you have on Witt? Tell me about Witt.
Did the lead investigator in this case ever hear you out about what you had to say concerning Cameron Poole?
Well, no, it was all Witt, 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 Witt.
Did the lead investigator in this case ever ask you a single question about a single person except for Miss Whitney Bowman?
Well, no. And when I couldn't give him anything on Witt, he hung up.
Thank you for your time, Mr. Hunter. Your Honor, nothing further at this time.
Thank you. State.
Yes, Your Honor, cross-examination. Before I begin, can I take down this chart?
Yes, remove the chart if you don't need it. He can, defense counsel can put it back up if he needs it.
Thank you.
Yes, Your Honor.
Good evening, Mr. Hunter.
Evening, ma'am.
My name is Caroline Kitchener. I'm just going to ask you a couple of questions tonight.
No problem. Go right ahead.
Mr. Hunter, you started working at Rocker World in 2009, right?
That's right. I started there as a janitor.
Then you moved up to a floating ride operator, right?
That's right, in 2010.
But Mr. Hunter, you always really wanted to be a journalist, right?
That's right, ever since I was a little kid watching NASCAR, that's right.
And about a year ago, that dream came true, didn't it?
It did indeed, yes.
You started working for the newspaper, the Midland's Voice?
That's right, I got a job there and started reporting on NASCAR, traveling the circuit.
But today, Mr. Hunter, you're just an intern for The Voice, right?
Oh, that's right, I still have to get my feet wet a bit.
Now, in 2011, you brought some of your stories to the editor. You showed them to the editor, right?
That's right, I'd written a series of stories on tire deflation and shock absorption, how the teams might have been cheating by using the system.
But at that point in 2011, those editors, they didn't want to publish any of your stories, did they?
Oh no, they thought they were too complicated for the general public, so they said, sorry, we're not going to publish them.
Well, actually, Mr. Hunter, what they said is, we're looking for something more scandalous.
Objection, Your Honor. Hearsay.
Overruled.
In fact, Mr. Hunter, they told you they were looking for something more scandalous. Isn't that right?
That's right. I guess tire deflation wasn't scandalous enough.
Now, today, you just published one article in the Midland's Voice, right?
That's right. I just got a story published about Darlington that happened this weekend.
You'd like to publish more stories, right?
Oh, sure. That's why I'm traveling the circuit, or I would until I came here today.
Well, in 2012, you actually started researching a story about Rocker World, right?
No.
Well, actually, Mr. Hunter, in 2012, you headed back to Rocker World to keep your eyes open, right?
Well, I still needed a job, yes. I needed something to pay the bills.
So that's a yes to my question, Mr. Hunter. in 2012, you headed back to Rockter World to keep your eyes open. Isn't that right?
That's right. I need to work, so I got to keep my eyes open.
Now, Mr. Hunter, you said that you like to write about cars, right?
Well, NASCAR specifically, and specifically the Sprint Cup.
Okay, Mr. Hunter. But to the best of your knowledge, this trial today, it's not about cars, is it?
Not that I know of.
It's about Rockter World, isn't it?
Well, that's right.
Now, Mr. Hunter, you're hoping that something comes out of this trial today, aren't you?
Well, that's right. Considering I live here in Midlands, I want to know what happened.
Thank you, Mr. Hunter. I have no further questions.
Any redirect?
No, Your Honor. May Ms. Hunter step down?
Mr. Hunter, you may step down. Thank you.
Thank you, Your Honor.
Well, a patented UCLA character witness. He takes me back to my childhood. I was a big fan of the Dukes of Hazzard, and he's straight out of that. I thought it was a solid witness. Nothing too flashy. Probably a little heavy on the NASCAR references. That's kind of a thing in mock trial these days, to call these southern hillbilly types with lots of NASCAR references. I thought he maybe went to the well a few too many times. That was sort of the big confrontation we wanted, though. We had Lampert there, we had Miss Kirchner there, and there really weren't many sparks. It was pretty standard witness. He got out what he needed to get out. If I were, nothing to see here, basically.
You can meticulously see, though, Ms. Kirchner laying the foundation for the closing argument. I can see it starting to build.
Absolutely, absolutely. They know what they're doing. She picked her moments. UCLA's crosses were much longer. They went through those affidavits and they brought out every point they possibly could. Princeton's being a little bit more, in your own words, meticulous about what questions they ask.
Chelsea on Twitter has mentioned one thing UCLA is doing already is adding backstories to the mix. How much do you think inventing character traits adds to the story in the eyes of the judges? Is that helpful?
Yeah, I mean, it's more entertaining. It gives the judges, if you just get up there and say, oh, this is my name, and start talking about the case. Is that realistic? Does that happen in real life? No, not necessarily, but again, this is a legal play. They are trying to score points with the judges, and it's good if you just get up there with an accent or, your love of NASCAR and you don't explain how you got those things. It's a little weird, so it's a good job of laying the backstories.
Several comments on Twitter, too, about the hat. You mentioned ties. We have hats here.
I would never let one of my students wear a hat in the courtroom. Obviously, it's worked out well for them. You run the risk of offending a judge if you sit in the back of the courtroom with a hat on. Judge Ferrer has probably seen it all, and so I don't think he's too concerned about it. It's working. It's part of his costume. I myself wouldn't be really comfortable with it, but it's certainly not the first time I've ever seen it.
Hey, we love the questions and comments. Keep them coming on Twitter using hashtag AMTANCT30.
Ready to proceed?
And it looks like you're ready for the next witness.
Yes, Your Honor. The defense calls Mr. Lou Eccles to the stand.
Okay. Mr. Eccles, you've been sworn?
Yes, Your Honor.
Okay. You may proceed, sir.
Yes, Your Honor. Good evening.
Evening, sir. How are you?
I'm doing well, thank you. Do you think you could introduce yourself to the members of the jury?
Sure. Good evening. I'm Louis Kennedy Eccles, but everyone around the park calls me Louie.
What park are you talking about, sir?
Rockter World Amusement Park. It's where I work.
What do you do at Rockter World Amusement Park?
Well, I'm the head of security there. I've been the head ever since 2012 on what happened to Officer Thomas.
Well, you've been head since 2012, but when were you first hired to work at Rockter World?
Well, I started out as a security guard back in 2009.
Do you think you could tell the members of the jury what your duties were when you were first hired?
Sure. I mean, it was basic security guard stuff, really. Patrolling the park, escorting out unruly customers, making sure kids kept it PG on and off the rides, making sure everyone had their own admissions bracelet.
What do you know about Rockter World's admissions policy?
Well, it's been the same ever since Ailey Floyd started working at the park back in 2010. She implemented a system where there were regular wristbands and VIP wristbands, and they would be different colors and have serial numbers on the sides.
Mr. Eccles, I want to go ahead and move forward then to how your duties as a security guard changed in 2012.
Sure.
Did they change at all that summer?
Oh, yeah. The boss, Mr. Longstreet, finally gave me the okay to make some security changes I've been wanting to make for years.
Well, what was the first of those changes that you made around the park?
Well, I installed a lock on the emergency exit door in the tunnel of tear.
Why would you have to do that?
Well, sir, employees were using the door to sneak out of shifts early and also to come in late. They were also sneaking their friends in without paying, so I had to stop that.
Well, was anyone there when you made this change?
Well, sure. The person who was running the ride at the time, Whit Bowman, was standing right next to me.
Did the two of you talk to each other?
Well, yeah, she asked me what I was doing, so I told her what I was doing.
Walk the members of the jury through what it is that you told Miss Bowman in this conversation.
Well, I told her there'd be no more leaving shifts early or coming in late, that they couldn't sneak their friends in anymore, and that if anyone wanted to go out of the tunnel of tear, they'd have to worry about that lock.
Your Honor, at this time, could I ask the court reporter to read something back onto the record?
What exactly are you going to ask the court reporter to read back?
If I could have the court reporter read something that Tyler Hartman said on her direct examination and see if Mr. Eccles can corroborate what Ms. Hartman said.
State?
No objection, Your Honor.
Since there's no objection, you can read it back.
Sir, I'm looking for what it is that Ms. Hartman said in regards to the lock to Cameron Poole in a conversation.
Do you have the ability to pull that up? Mr.
Tyler Hartman.
Hartman.
The very first witness. She had a conversation with Cameron Poole talking about a lock.
Do we have two court reporters? Just one, and an assistant. So you have two people who want to kill you right now.
Certainly.
Okay.
It's in the very first witness of the trial. It's you have to worry about the lock or something along those lines. That wasn't quite it. But if nothing else, I can just ask the witness and tell him what we heard today.
Well, we can see how that goes.
Sure.
Try that.
Mr. Eccles, what we heard in trial today from Ms. Hartman was that she told Cameron Poole that they would have to worry about the lock.
Objection.
Overruled.
Is that what you told the defendant to let everyone know?
Well, yeah, I told Whit that if anyone wanted to go out the emergency exit, they'd have to worry about the lock. It's exactly what I told her.
So is what Ms. Bowman told Cameron Poole exactly what you told her to let everyone know?
Verbatim, yeah.
Well, Mr. Eccles, after you had Ms. Bowman let everyone know that they couldn't go to work late anymore, did you have a problem with employee tardiness?
Nah, people started showing up on time.
And after you told Ms. Bowman to let employees know that they couldn't cut out of their shifts early, did you have a problem with employees leaving the park early?
No, sir, we didn't.
Well, sir, you said you implemented some changes in the summer of 2012.
Yeah.
What else did you change?
Well, the second change I made was to start standing out in front of the main ticket booth toward the last hours of the day in order to make sure that employees weren't leaving early and that kids weren't sneaking back into the park using discarded wristbands.
Mr. Eccles, say that someone was leaving or entering the park between 7 and 9 p.m. on August 29th. Would they have had to pass you by?
Yeah, they would have had to walk right past me.
Well, I want to move on then to talk about August 30th, the
Sure.
next day. Were you working?
I was, yeah.
Could you walk us through how that day started for you specifically?
Well, it started with all the employees being on time for a change, which was nice.
What else happened that morning, if anything?
Well, I saw a heated conversation between the park's owner, J.C. Longstreet, and the usual ticket taker, Cameron Poole.
What did you do upon seeing this heated conversation?
Well, I immediately went over to see if Mr. Longstreet required my assistance. But as soon as I got there, Cameron turned and stormed away. And Mr. Longstreet immediately turned to me and said that Cameron had just been fired. He hadn't taken it well. I should keep an eye out for him.
Objection? Hearsay?
Let me hear that again. Can you read that back? I'm not going all the way back, just this last question.
I immediately went over to see if Mr. Longstreet required my assistance. But as soon as I got there, Cameron turned and stormed away. And Mr. Longstreet immediately turned to me and said that Cameron had just been fired. He hadn't taken it well. I should keep an eye out for him.
May I be heard?
Yes.
This is an exemption to hearsay under Rule 8031, present sense impression. May I proffer?
How that's a present sense impression?
Yes, Your Honor.
Yes, proffer.
What we just heard, Your Honor, is that there was an event, Cameron Poole being fired, and that the declarant, immediately after this event took place, described that event to Mr. Eccles. That qualifies under 8031.
And what's the relevance of it?
This is relevant in that we established that Cameron Poole hadn't taken being fired well. It's the defense's contention that Cameron Poole wasn't in cahoots with Whitney Bowman, but rather, on August 30th, he committed a crime of passion, independently because he had been fired and not taken it well.
But how does him committing a crime of passion eliminate Miss Bowman?
Because it was a spur-of-the-moment action, Your Honor. That would lessen the chance that Miss Bowman could have been involved.
I see. Okay, so the nature of the comment was that he
had
was
just been
told by
fired.
Mr. Longstreet that he had just fired Mr.
Poole, Your Honor.
Poole, and Mr. Poole had not taken it well.
Yes, Your Honor.
Your Honor, may I respond?
Yes.
There's another, the last clause in that statement is that Mr. Eccles should keep an eye on Mr. Poole. That's no longer describing the event.
If I may be heard on those grounds.
Go ahead.
As for the latter portion of that statement, that isn't being offered for the truth, but rather to go to the effect on Mr. Eccles, the park security guard.
What was the effect on him?
As security, it's his job to keep an eye out for things, and what he'll tell you in further questioning is that he did in fact see Cameron Poole later. My next question is going to be, did you end up seeing Cameron Poole later?
Again, I'm having trouble following where that part would be relevant in this case.
Where which part, Your Honor?
The fact that he told him keep an eye out for Mr. Poole.
If counsel would like to strike that part of the question, answer rather, that's fine.
Your Honor, I do believe that statement should be stricken for the record.
Okay. All right. I will overrule it as to the first part of the statement, and I'll grant your motion to strike the second part.
Mr. Eccles, did you end up seeing Cameron Poole later that day?
Unfortunately, I did.
When?
Well, it was a little after 8 p.m. I was standing out in front of the park, like usual, when I started to feel sick, so I went to go sit down on a park bench. As soon as I sit down, I saw Cameron Poole come bursting out of the ticket booth with Officer Thomas and a person who I later found out was Detective Kimball, hot on his heels. I tried to follow them, but I was too sick to stand, let alone run.
Mr. Eccles, do you know what happened to Officer Thomas that night?
I do, yeah.
Given what happened to him, did you talk to the police?
Well, I tried to.
What do you mean you tried to talk to the police?
Well, I talked to a Detective Kimball about an hour after the robbery took place.
What did the detective ask you about?
Whit Bowman. Specifically and only Whit Bowman.
Did you have things to tell the detective that didn't involve Whit Bowman?
Well, yeah. I tried to tell him what I knew about Cameron Poole, what I'd seen earlier in the day, but he was having none of it.
Did you ever get an opportunity to tell the investigating officer those things you knew about Cameron Poole and what you had seen at the park?
Nah. I tried to walk after him after he tried to end the interview, but he turned around and threatened me with arrest if I didn't stand down. So I let it go. All we ended up talking about was Whit Bowman.
Thank you for your time today, sir.
Sure.
Your Honor, I have no further questions at this point.
Okay, State.
Yes, Your Honor.
Mr. Chow.
Mr. Eccles,
Yes, sir.
I just have a few questions for you about that door in the back of the tunnel of terror.
Emergency exit door, sir?
That's right.
Sure.
Now, throughout the summer of 2012, you noticed a problem with that door, right?
Well, yeah, that employees were using it to sneak out and sneak their friends in.
And that was a security breach, right?
Well, yeah, also a customer breach.
So you wanted to put a lock on that door.
Yeah, of course.
And you installed that lock on August 28th, 2012.
I believe so, yeah.
So on August 28th, you went over to the Tunnel of Terror.
Yeah, of course.
And the person standing behind the controls of that ride was the defendant, right?
Yeah, Whit was running the ride at that point.
And when you saw the defendant, she asked you if she needed you to put, she asked you whether you wanted her to put the ride into maintenance mode, didn't she?
Yeah, I told her I was going to do some maintenance. She asked me if I wanted to put in maintenance mode, and I said, no, just turn it off.
I just want to be clear, Mr. Eccles. Maintenance mode is a mode on the ride when the lights turn off, but the ride keeps moving.
I think so, yeah.
But you had her stop the ride, right?
Well, yeah, I'm not going to walk into the ride while it's still moving.
So the defendant pushed the red button and stopped the ride.
Yeah.
And you walked into the ride to the back of the tunnel.
Yeah, me and Whit went into the ride.
That's right. The defendant followed you all the way to the back door.
Yeah, I had to come with me.
And she asked you what you were doing.
Yeah, she asked me about the lock.
And then she stood there and watched you the entire time you were installing that lock.
For about the 30 seconds it took, yeah, she was there.
Now, I just want to be clear. This is a padlock, right?
Yeah.
There's a key that opens the lock?
Yeah.
And there's one key.
Well, yeah, it wouldn't be much of a lock if there was more than one.
And after you installed that lock, you took the key and you gave it to the defendant, didn't you?
Yeah, I gave it to Whit. I told her to hang it up in the control booth.
You gave the defendant the key to that lock just 2 days before the robbery.
Gave it to her on August 28th, so yeah.
Thank you, Mr. Eccles.
Sure.
I have no further questions.
Defense, any redirect?
No redirect, Your Honor. At this time, may the witness step down?
Yes. Mr. Eccles, you may step down.
Thank you, Your Honor.
Thank you, sir.
So Kyle DeCamp does it.
The first mistake is listening to anything I say ever. Yeah. Apparently, Mr. DeCamp was in the hallway while we were commentating, and huge risk, huge swing, huge miss.
Yeah.
That was awkward. It took up a bunch of time. High risk, high reward. It did not reward. Nevertheless, it was a decent direct. I like this witness. I liked his accent. There's some Twitter hate right now about the accent. I kind of like this one. I think this is the best accent that we'd had thus far.
Most believable, perhaps.
Most believable. Yeah. There's a lot of anger over his tie, which was not straight. I also noticed that. It was a nice tie, though, so I'll give him credit. A good witness. He got out what he needed. He was believable. You're right. He looks like he's 10 years old, but he was a very believable witness. Again, we're seeing the same pattern, a fairly short cross-examination from Princeton. They're picking their points, setting up. They've really kind of minimized their case, what they're trying to prove. And late-breaking news, I'm told by former American Mock Trial Association tabulation director Christopher Lyons, per Facebook, that Princeton in fact won the toss and chose to go prosecution.
There you go.
Again, something I would have not done, but kudos to them. That's the choice they made.
We also had some clarity on the question that came up about what if all the judges tie in the
Correct.
final round. And Jonathan has let us know that Princeton would win because it won more ballots in the initial 4 rounds.
Absolutely. So if all 5 judges tie, and this is Orlando, crazier things have happened.
It's true.
The defense, or excuse me, the prosecution, Princeton, would take the ballot. Another thing we just saw, there was finally a good objection battle. Judge Farrar finally let them argue. Judge Farrar effectively using the court reporter. That's why he's on TV. He knows how to do it. He used her very effectively, showing Mr. DeCamp how it's done. so to speak.
Those are the moments we relish, letting the attorneys go head to head and battle it out, and really see them shine.
Yeah, and it was the first time, and both made incredibly good, excellent arguments. I don't think Judge Farrar's rulings have been wrong thus far. I think he's been pretty on point with everything. He's been pretty, quick to make rulings. We just saw another picture of our esteemed judging panel, and the combatants. So they're there again. They look a little disinterested, I'm not going to lie. Judge Rose is maybe asleep with his eyes open. Judge Rose may be asleep with his eyes open. Oh, no, there's some movement. But I know they're enjoying themselves. They got to love this, seeing young folks already so good at this legal stuff.
We do have, despite the little hiccup we had, Elisa is on Twitter is advocating for the court reporters in every tournament. That would make rounds much easier, and she's creatively used the hashtag mocktrialproblems to accentuate that point. But perhaps that's something you guys can consider in the off season.
Correct, and I saw Aaron Kreider pointed out. Big twist, the court reporter with an accent. Wouldn't that be funny if the court reporter also had an accent? Excellent comment, Aaron Kreider. I appreciated that.
Ready for your next witness?
And here we go.
Yes, Your Honor. The defense would
Final
like
witness.
to call Miss Becky Conroy to the stand.
Okay. All right, Ms. Conroy, you're under oath?
Yes, Your Honor.
Okay, you may proceed.
Good evening.
Good evening.
Would you please introduce yourself to the ladies and gentlemen of the jury?
Hello, everyone. My name is Becky Phyllis Conroy.
What do you do for a living, Miss Conroy?
Well, my real passion is actually cat breeding. I specialize in exotic short hairs, but I also have a day job. I own and operate the finest water park in all of Midlands, Ruel's Rivertown.
How long have you owned and operated Ruel's Rivertown?
Let's see, it's been about 15 years now. We opened up back in 1999.
Now, Miss Conroy, we've heard a lot about a man named Cameron Poole in today's case. Do you know him?
Oh yes, Cameron. He's one of my former employees.
What about Miss Whitney Bowman?
Oh, Whitney. Yes, she also used to work for me. She applied to work at Ruel's a few years back, and I personally interviewed her. I remember I hired Whitney on the spot when it seemed like she liked these pictures of my cats.
From your perspective as an employer, Miss Conroy, what was Whitney Bowman like as an employee?
Oh, Whitney was an excellent employee. She was the kind of person who'd always go above and beyond the call of duty. I remember she'd always follow my rules, and she'd even check in with me before she went on break or left work for the day.
From what you could see, was Miss Bowman well acquainted with other employees at the park?
Yes, I remember the other employees really liked Whitney. She would always be willing to take over for their work shifts if they had to miss work for some reason.
And based on your observations, Miss Conroy, would you say that Miss Bowman was an honest employee?
Absolutely. One of the best examples that I can think of is one time I paid Whitney too much, but the next day she gave that money right back to me.
Well, Miss Conroy, are you familiar with another amusement park in Midlands called Rockterworld?
Oh yes, Rockterworld. I've been there many times myself. I even know the owner, Mr. Longstreet.
When would you say the most recent time you went to Rockterworld was?
Let's see, the last time was August 29th, 2012. It was the day before they had that tragic incident with their security guard.
Did you see Miss Bowman at Rock-to-World on August 29th?
Yes, actually, I saw Whitney working there that day. She was operating the Tunnel of Terror, that old piece of junk.
Why do you say that?
Well, we had that very same ride at my park, Ruel's, but it had been given us so many problems.
What do you...
Your Honor, more prejudice than probative. May I explain?
Yes.
Your Honor, for the witness to testify here in court that she found the ride so unsafe in 2008 without laying any foundation as to how the ride was changed or unchanged by 2012, when the crimes being discussed here in court today actually occurred, would unfairly prejudice the jury.
Defense?
Yes, Your Honor. We're establishing Miss Conroy's knowledge of the ride before going into her further knowledge of the ride and seeing it in 2012 and whether or not those problems had been, in her opinion, repaired.
So your objection is unfairly prejudicial as compared to its probative value?
Yes, Your Honor.
Okay, I'll overrule it on those grounds. You may continue.
Miss Conroy, you were telling us about the problems you noticed with the Tunnel of Terror when it was at your park.
Yes, I just was saying that when I had that very ride, we had many issues with it.
What kind of problems?
Well, there were two main problems with the control panel. First, it was just too small, and the second issue was the fact that it was laid out very poorly.
Well, I want to take those one at a time. What do you mean by saying that the control panel on the Tunnel of Terror was too small?
Well, that control panel, it was just tiny. I mean, the buttons were only about an inch big, and the entire width of the control panel wasn't any more than about 10 inches.
What about the second issue you mentioned? What was going on there?
Well, the layout, it was very problematic. I saw two of my most experienced ride operators nudge that maintenance lever when they were reaching for the stop button.
How many times did you see that happen?
Well, I personally saw it happen twice with two different operators, and that was within the span of a couple of months.
Miss Conroy, did you ever have the Tunnel of Terror control panel repaired to fix those problems?
Well, I looked into it, but it would have cost more than the entire ride was worth to fix that problem, because we'd have to take out the whole control panel and put a different one in.
So what'd you do with the ride?
I knew that old thing was a dud, and I thought it was too much of a liability to have at my park, so I wanted to have it hauled off to the dump.
Did you have it hauled off to the dump?
Well, that depends on your definition of a dump. The ride is at Rock-to-World now.
Why is the ride at Rock-to-World, Miss Conroy?
Well, the owner of Rock-to-World, Mr. Longstreet, he bought that ride from me.
Well, ma'am, I have to ask, why did you sell a ride that was having operational difficulties to be used at another park?
You see, that's the thing. I was under the impression that Mr. Longstreet was going to take the ride apart and just use it for the spare parts. I never would have sold him the ride if I thought he was going to let people...
Speculation as to Mr. Longstreet's intentions?
Defense?
Your Honor, I believe the witness was testifying about her intentions, not Mr. Longstreet's.
I'll overrule it.
Miss Conroy, had you quite finished your answer?
Oh, not quite. I was just saying that if I had known Mr. Longstreet was going to use the ride as is, I wouldn't have sold it to him.
Well, then I'd like to turn your attention back to your visit to Rock-to-World on August 29th. Did you see the Tunnel of Terror ride at Rock-to-World on that day?
Yes, I did. I saw the Tunnel of Terror that day, and I saw the control booth.
how did you get to see the control booth?
Well, when I was at the Tunnel of Terror, I saw Whitney, who was operating the ride, walk out. She went and talked to another employee, and I just walked in.
How did you just walk into the control booth?
Well, there wasn't a door or a gate or a rope, so I just went in.
And when you went into the control booth, did you get a chance to look at the control panel you were just telling us about?
Oh, yes. That's why I went in. I wanted to see the control panel.
From what you saw, Miss Conroy, was the control panel you saw on August 29th of 2012 different in any way from the control panel of the Tunnel of Terror at your park?
It didn't look like it to me. It looked just the same. Even that ugly graffiti was still on there.
Did the control panel that you said was giving you operational difficulties appear to have been repaired when you saw it on August 29th of 2012 at Rockter World?
From what I...
Calls for speculation.
I'm sorry. Say again.
Calls for speculation as to how the witness would know if in the 4 years when she didn't own the ride, if it had been worked on.
If it appeared the same? Was that your question?
I believe the question asked if the ride had actually been operated on her. Sorry.
Re-ask the question, please.
I asked if the ride appeared to have been repaired. Would
Thank
you like me to clarify?
Well, why don't you change the wording of it, and then I won't have to sustain it.
Miss Conroy, you told us earlier that in order to repair the control panel in the Tunnel of Terror, you'd have to replace the entire thing. Did the control panel that you saw on August 29th appear to have been replaced?
No, from what I could tell, it was the same control panel that had given us all those problems at Ruel's.
Objection, Your Honor. Again, speculation.
Overruled. Deal with it on cross.
Thank you for your testimony, Miss Conroy. I have no further questions at this time.
Thank you. State, your cross.
Yes, Your Honor. Good evening, Miss Conroy.
Good evening.
As you told us earlier, on direct examination, you own your own amusement park, right?
That's right. I own a water park, Ruel's Rivertown.
And that's right here in Midlands, right?
Absolutely.
Rockter World, it's also in Midlands, isn't it?
Yes, that's right.
As you told us before, you even know its owner, Mr. Longstreet. Isn't that true?
That's right.
You would say that you and Mr. Longstreet know each other from way back, right?
Yes.
But Mr. Longstreet, he's a business competitor, isn't he?
Yes, he's one of my business competitors.
His park, it competes directly with your park, doesn't it?
Yes, but I would say it doesn't compete very well.
Now, Ms. Conroy, you talked on direct examination about the Tunnel of Terror.
Yes.
I'd like to ask a few questions about that.
Sure.
Now, you said earlier that you actually sold that ride to Rockter World, didn't you?
Yes, that's right.
You said that you sold that ride to a business competitor, right?
Yes, that's right. I sold that ride to Rockter World for cheap, so Mr. Longstreet could use it for the parts, or so I thought.
That was in 2008?
Yes, that's right.
You also told us that on August 29th of 2012, you got a chance to actually go on that ride, right?
Yes, I saw the ride at Rockter World.
But Ms. Conroy, on direct examination, you said that you wouldn't have sold the ride if you thought that Mr. Longstreet was going to continue allowing it to operate, didn't you?
Yes, when I saw the ride there, I was happy. I thought Mr. Longstreet had fixed it up, but when I saw the control panel, I knew otherwise.
On August 29th of 2012, you felt safe enough to actually go on that ride yourself, right?
Yes, at first, until I saw the control panel.
When you got off the ride, you were able to take a glance at the control panel, right?
That's right. I saw the control booth and the panel inside.
And you said on direct examination, it looked the same as when you had owned it, right?
Exactly. It looked the same size, same layout.
It looked the same as you remembered it from having owned it 4 years ago?
That's a very hard ride to forget.
Now, Miss Conroy, besides knowing that it looked the same, you don't know if there was any work that was done on that control panel, do you?
Well, based on the appraisal I got of the ride, I knew that to fix it, you'd have to take out the control panel, and when I saw that the control panel was the same, I knew it hadn't been fixed.
But Miss Conroy, you can't say for sure if Mr. Longstreet had taken any measures to fix the internal workings of that control panel, can you?
No, I don't know if he did anything with the internal components.
Miss Conroy, you also talked about a problem that you were noticing with the ride and the use of blackout mode when you owned it, right?
Yes, our ride operators would nudge that blackout or maintenance lever when they were reaching for the stop button and it would go off.
And just to be clear, you only saw that happen at your park 2 times?
Yes, that's right. 2 times, 2 different operators within the span of 7 or 8 weeks.
But Miss Conroy, when you visited the control booth and you saw the control panel on August 29th of 2012, you didn't reach down and pull that blue lever, did you?
Of course not. That would have been dangerous.
So, Miss Conroy, you don't know if the resistance of that lever has changed since you own it, do you?
No, I don't know.
Miss Conroy, you train your employees at Rules Rivertown, right?
Yes, of course.
You trained the employees who were accidentally hitting that blue lever?
Yes, I trained my employees very thoroughly, and when I saw that they kept having that issue, I knew it was an issue with the ride.
But you don't know how Rockterworld trains its employees, do you?
No, I
don't. You don't know how Rockterworld trains the employees who operate the Tunnel of Terror, right?
No, it's not my park.
You can't tell us at all how the training of the employees at Rules Rivertown compares to the training of the employees at Rockterworld, right?
No, I've never been to a Rockterworld training session.
Thank you, Ms. Conroy. I have no further questions at this time.
Okay, defense, any follow-up?
A very brief redirect, Your Honor.
Are we having a moment here or something?
I'm checking the time, sir.
Okay. I thought you were looking at me waiting for instructions.
Ms. Conroy, how could you specifically tell that the control panel at the Tunnel of Terror hadn't been switched out?
Well, there are a couple of things. If the panel had been switched out for a new one, it wouldn't have had that same graffiti on the surface that was there when I had it. And also another clue was if you look at the screws in the corners, they were stripped, which means they don't have that little cross in it. If the control panel had been taken out, the screws would have been replaced. They wouldn't have been stripped anymore.
Thank you, ma'am. No further questions.
Okay, thank you. Anything else, State?
Brief recross, Your Honor. Ms. Conroy, you just said that when you looked at the control panel, that you were able to tell that the screws were stripped down and that the graffiti was exactly the same, right?
Oh, wait. There might have been a couple of additions of the graffiti, but I did recognize much of the graffiti that was already there.
But when you were getting off the ride and actually looking at the control panel, you only really glanced at it, right?
Yes, I glanced in at the control panel when I went into the booth.
Thank you, Ms. Conroy. No further questions.
Thank you. Nothing else?
No, Your Honor. May Ms. Conroy be excused?
Yes, Ms. Conrad, you may step down. Thank you very much.
Thank you.
Well, the case in chief for both sides are officially over. We're going to take a break here for a few moments before the closing arguments. Of course, the commentators aren't taking a break. We're going to stay live with you folks on the live feed. The last witness, Beckett Buttons Conroy, doing her best impression of my mother, the crazy cat lady, complete with the cat-themed purse in the frame the whole time. A brilliant move on her part, but I have to wonder, are the judges on character witness overload right now?
You know, that's exactly what Maggie pointed out on Twitter, too. She said UCLA went for 3 dramatic characters. Are they taking away from each other? Are they becoming a little bit hard to differentiate because of it?
Yeah. The judges have been given a clear...
Does anybody need a break before we go into closings?
We're ready to proceed, Ron.
Okay. State's ready as well?
Yes, Your Honor.
Okay. State, you may proceed.
May it please the court, opposing counsel, ladies and gentlemen of the jury. Just before 8 o'clock on August 30th, 2012, the defendant was standing behind the controls of the Tunnel of Terror. Now, she stood there waiting anxiously for any hint, any indication that the plan was being put into motion. Now, she didn't have to wait long. Screams, footsteps pounding against the pavement, clutching a knife in one hand and a bag of cash in the other. Mr. Poole sprinted directly toward the defendant, heading right for the employee exit at the back of the Tunnel of Terror ride. It was Miss Bowman's job to make sure that he got there. And so, at exactly the right moment, as Mr. Poole and Officer Thomas were running into the ride, Miss Bowman pulled a blue lever. A lever that every Rocker World employee knows never to touch. A lever that plunges the entire ride into darkness. The defendant pulled that lever. Cameron Poole got away, and Winston Thomas was killed. Ladies and gentlemen, the question that we have asked ourselves today is who was behind the controls? Who made it possible for Mr. Poole to escape? After all of the testimony that we have heard in this court today, the answer is clear. It was the defendant. When the defendant and Mr. Poole stole over $500 from Rocker World by creating a false impression, they committed theft by deception. And when they used force for that theft, they committed robbery. And because Winston Thomas was killed as a direct and proximate result of the defendant's actions, the defendant is guilty of felony murder. I want to talk about each of those charges in turn today. First, theft by deception. Now, in Midlands, theft by deception means stealing by creating a false impression, by lying. Miss Bowman, she lied to Mr. Isaacs when she said the boss gave him permission to go home early. And Mr. Longstreet, he never said Mr. Isaacs could leave the ride, and he never said Miss Bowman could operate the Tunnel of Terror. That was all a lie told so that the defendant could be standing behind the controls at exactly the right moment. Now, the use of force to commit theft, well, that's called robbery. Now, Cameron Poole threatened Haley Floyd with a knife so that he could steal all of the money from the Rock to World ticket booth. Miss Bowman, she helped Mr. Poole escape with that money, making her complicit to robbery. Now, we're not saying the defendant was the one who held the knife or the one who ran through Rock to World with all the money. But ladies and gentlemen, she was the one who made it possible. In Midlands, that's called complicity. Complicity means that if you help someone to commit a crime, you are guilty of that same crime. So, how do we know that Miss Bowman helped Mr. Poole escape with that money? Well, Ms. Hartman told us today that just a few days before the robbery, she heard Miss Bowman say to Mr. Poole, "Don't worry, I have a plan." There's a door at the back of the Tunnel of Terror. Mr. Isaacs took the stand today and told us that on August 30th, Miss Bowman asked to take over the Tunnel of Terror 3 times. He also told us that she had never once insisted on operating that ride before. But on August 30th, the defendant knew the plan and she knew where she needed to be. Right after Mr. Poole crossed the tracks of the Tunnel of Terror, she pulled the blackout mode lever, and the ride went completely dark. Now, the defense, they tried to tell you that was a mistake, but it wasn't. It was murder. Now, we've shown you today that Winston Thomas was killed as a direct and proximate result of the defendant's actions. Now, no one disputes the fact that Officer Thomas died as a direct result of what happened in the Tunnel of Terror on August 30th, which leaves proximate cause that Officer Thomas's death was foreseeable. Well, we heard from multiple Rock to World employees today that blackout mode, it's dangerous. Everybody knows it. The cars in the ride keep moving, but all of the lights are shut off. Now, the defendant, make no mistake, ladies and gentlemen, she knew exactly what that lever did. Mr. Longstreet took the stand today and told us that he'd found Miss Bowman operating blackout mode on the Tunnel of Terror before. And when he did, he told her she could never operate that ride again. As Mr. Poole sprinted into the Tunnel of Terror, the defendant was standing behind the controls. She stood, she watched, she waited. She didn't run away because she didn't think she was going to get caught. Well, the defendant, she didn't know that Ms. Hartman had overheard her conversation with Mr. Poole about the back door of the Tunnel of Terror. She didn't know that her friend Billy Isaacs would take the stand today and tell us just how many times she asked to take over the Tunnel of Terror on August 30th. She thought she would be safe standing behind the controls. She was wrong. Find her guilty. Thank you.
Thank you, Ms. Kitzner. Defense?
Yes, Your Honor. something's missing from the story you just heard. We didn't hear anything about any scientific evidence linking Miss Bowman to this crime, any financial evidence linking Miss Bowman to Cameron Poole's crime, any forensic evidence linking my client to Cameron Poole's choices. But if there's one thing that wasn't missing from the state's argument just now, it was this word: defendant. Members of the jury, you notice how many times the prosecutors chose to call my client defendant? Say it was the defendant standing behind the controls. Do you know why they do that, members of the jury? It's no lawyer's trick. Because defendants wait in the shadows. Defendants sound like schemers and plotters. Defendants make plans. But people make mistakes. The more you think of Miss Bowman as just the defendant waiting behind the controls, the less you think of her as a person. Members of the jury, this is Whitney Bowman, a young lady who was in the wrong place at the wrong time, a young woman who made a mistake and is now being charged with murder. We learned today that Miss Bowman was an honest, hard-working, caring young woman. A woman who was happy to help out her friends at both amusement parks she worked at. A young woman who has been railroaded into a murder charge by the detective the state chose not to even present to you today. But members of the jury, in this country, there's something called the presumption of innocence. And what that means is that when Miss Bowman walked through those doors, she was presumed innocent of those 3 crimes the state told you about. As she had to sit there and listen to them call her the defendant, waiting in the shadows again and again, she remained presumed innocent. And we're confident at the end of today's trial, you will find Miss Bowman not guilty, because the state has failed to meet their burden of proof. So what is that burden, members of the jury? It's the state's job to prove to you beyond a reasonable doubt that Miss Bowman is guilty. Now that means that if your reason and your common sense lead you to ask any questions about their story, if there's another single reasonable other explanation for what happened at Rockterworld, that means the law demands you can't find Miss Bowman guilty. Remember, it doesn't take 20 reasonable questions, or 10, or 5. All it takes is 1. And we're going to talk about the 3 most important questions the state has failed to answer. Question number 1, where's the money? Miss Bowman was charged with 3 financial crimes. People commit financial crimes in order to get money, and when they have that money, either they'll spend it or they'll save it. So where's the evidence that Miss Bowman benefited in any way from Cameron Poole's robbery? Do we have evidence that she went out and got a new house, a new car, new clothes? If she was keeping any of the money, where was she keeping it? In a bank account? Did we hear about her bank account at all? Did we hear about a financial investigation at all? Was the financial investigator called to the stand at all? On top of that, members of the jury, the state told you at the start of their closing argument that Cameron Poole was seen running away with a bag full of money. If you remember the direct examination of J.C. Longstreet, what Mr. Longstreet said is that on average, over $20,000 a day, that's what the ticket booth brought in during the month of August at Rockterworld. That's a lot of money to stuff into some kind of sack, members of the jury. You can't just put that in your pockets and run. But we heard from the single eyewitness the state decided to call, the single person who witnessed Cameron Poole's escape, that she didn't see him carrying any kind of money. She didn't see a sack. She didn't even see a knife. Is that proof beyond a reasonable doubt? If you're wondering where Cameron Poole allegedly put all of these thousands of dollars, if you're wondering what happened to that knife, if you're wondering where the money is, that is reasonable doubt. That brings us to our second question. What happened during that escape? The state's single eyewitness, Tyler Hartman, told us that there was panicked yelling, chaos, and confusion, that she couldn't tell exactly where my client was. At one point, the lights went out. She couldn't see anything. She couldn't even tell if Cameron Poole said anything to anyone because the screams, they were so loud. Members of the jury, this traumatic event happened over a year ago. You think she's going to remember the exact timeline, step by step by step? Human memory, it's unreliable at best. So do we have any evidence, any surveillance footage of what was going on there? Do we actually see a picture of my client behind the controls? Or did my client make the simple mistake that others had made before? Jack Hunter, Billy Isaacs, 2 employees back at the other amusement park, of in all that chaos and that panic and that bang sound, accidentally hitting that lever. If you think that's a reasonable possibility, members of the jury, Ms. Bowman can't be found guilty. And that leads us to question